Hey, good morning, council. Who's announcing for the state for position number 320 SC 176954 state versus Armon McGee?
Brian Shepherd on behalf of the state, Your Honor.
All right, I have this down for final plea today. Where's the state?
Yes, Your Honor. As it relates to Mr. McGee, the state has extended an offer. Mr. McGee is charged in this case. It is a 5-count indictment. On count 1, armed robbery carries a minimum of 10 with a maximum of 20 years or life. Count 2, hijacking a motor vehicle in the first degree carries a minimum of 10 with a maximum of 20 years to serve. Count 3, aggravated assault with a deadly weapon carries a minimum of 1 with a maximum of 20 years to serve. And possession of firearm during commission of certain felonies carries 5 years consecutive to other counts. And count 5, possession of firearm by convicted felon carries a minimum of 1 with a maximum of 10 years to serve. The state.
So the maximum, there's no merger. And
so there would be a merger with count 3 and count 1. So aggravated assault would merge with count 1. Hijacking of a motor vehicle in the first degree does not merge with other counts.
So it looks like life plus 35 years is the maximum.
That's correct, Your Honor.
Okay.
The recommendation that the state made that provided to Ms. Zimbardi via email was on count 1, 15 years to serve, 10 years, the balance to be probated. Count 2, 15 years to serve, 10 years, balance probated concurrent with count 1. Count 3 would merge with count 1. Count 4, 5 years consecutive to count 1 probated. And on count 5, 10 years to serve concurrent with count 1 for a total of 20 years to serve 10 years, the balance on that case to be probated. And I would, if this were to be a plea, a special condition of the stay away from the victims in this case, not that I think that would be an issue. It's my understanding, obviously I'll let Ms. Zimbardi make the announcement, but I do not believe we've reached a resolution today.
Okay, let me go ahead and get announcements from the defense with respect to where you are.
Understand that today is the final plea, and it's all the interim plea, whether that be negotiated or non-negotiated,
All right, so Mr. McGee, thank you, Ms. Zimbardi. You can be seated. I have all my cases, criminal cases, appear on a final plea before we put it on a trial calendar. It's just important for you to understand what your options are. It's your choice entirely. There's no pressure from anybody, the court or anybody. It's big decisions. It's your decision on what you want to do. You have an absolute right to a fair trial, and you'll get that if that's what you want to do. But I do give defendants an opportunity to come before the court at final plea. I have the court go on the record, as Mr. Trepunet has done, with what the sentence range is, just so there's clarity and your presence in mind on what the potential outcome could be if you are convicted of all counts. And I want to have clarity from the state on what their offer is. We have that clarity. Sometimes that changes leading up to today. So it's good to have this day in court for them to go on the record as to what the offer is. Importantly for you, you should understand that today is the last day that I commit to taking a guilty plea on this case at all. The court never has to entertain a guilty plea. Of course, courts will regularly consider them because it makes sense to do so. However, I have to afford you a fair trial, and I will, but the court never has to entertain a guilty plea. It's all at the discretion of the court. Also, you have the ability today to hear what the state says, enter your plea, and if it's a negotiated plea, commit to being bound by the negotiated plea. If it's a non-negotiated plea, you have the ability to withdraw your plea through today on whatever kind of plea you put up. Get my sentence after you plead guilty and you don't want to go along with that sentence today, you can withdraw your guilty plea after hearing my sentence and go to a trial. After today, 1, I don't commit to taking a guilty plea. 2, if I do take a guilty plea, under no circumstances after today can you withdraw it. Meaning if you even come before me with a negotiated sentence recommendation, I'm not bound by the negotiated sentence recommendation. I will not be bound by that after today. And I would sentence within the legal range, no matter what the state recommends or you recommend after today. If you enter a guilty plea and I announce my sentence, you cannot withdraw your guilty plea after today. So do you understand that? Okay. You understand the sentence range with the maximum potential if convicted, and if you were sentenced to the maximum would be life plus 35 years. Do you understand that? Okay. You understand that the offer from the state is for all the counts 20 years to serve 10 years in custody, the balance on probation. Do you understand that? You understand if you are convicted of either armed robbery or hijacking, the minimum is 10 years to serve. You understand that? All right. So what is your decision? Do you wish to maintain your not guilty plea and go to trial, or do you wish to enter a guilty plea? Okay. You absolutely can maintain that you are not guilty. Is that what you said? Okay. All right, Mr. McGee, we'll place you on a trial calendar. You'll get notice of when that trial calendar will be. We are placing cases on a court-wide trial calendar right now, and we're looking at how long people have been in jail as the priority cases. So that is what's going to gauge when your case goes on a trial calendar and when it gets reached. As judges, we are limited to 3 cases per trial calendar right now. So we have some limitations based on COVID, but you will be in line for trial. Okay. Anything else with Mr. McGee's case for today for the state?
Nothing further from the state, Your Honor.
Of the defense. All right, Mr. McGee, you can be excused. State and defense, are you both ready on position number 1, Norris Dixon?
Yes.
All right, let's bring out Mr. Dixon.
I have done a plea sheet with him. He just needs to sign it, and I believe we need the indictment, as we do have a negotiated plea for your honor.
For his 2 cases?
Yes, both of us.
All right. Thank you. Thank you. All right. No problem. Hey, Mr. Dixon. Oh, this up. Ms. Hilton, you're handling this for the state?
Yes.
Okay, so sign this top one. And sign that one there. This is the sheet that we went through. That's signed by the state too. Oh, it changes every day. So what we have been doing, I think, is it Miss Zimbardi? Where do you want to stand? And we could have your client. What we've done is have the client at the microphone. It's important that we hear the defendant. We could have you at your counsel table, and we could have Ms. Hilton over here by the witness stand so that everybody can be heard. How does that sound?
Yes.
All right, Mr. Dixon, good morning. Come up to the microphone. Do we know if the microphone is on? It's on? Say something, Mr. Dixon, in the
Yes,
microphone.
ma'am.
Hey, we can hear you just fine. All right, well, sir, we are on the record in your two cases. The two indictments before me are indictment 20 SC 176822. That's the one in which you were charged with 6 counts, including 3 counts of aggravated assault with a deadly weapon. And then indictment 20 SC 176869, you're charged with 1 count of battery family violence. We're going to begin by having our Assistant District Attorney, Ms. Hilton, swear you in. She's right here.
Mr. Dixon,
Yes,
will you
ma'am.
please raise your right hand? Do you solemnly swear that the testimony you give in the court shall be the truth, the whole truth, and nothing but the truth so help you God?
Yes, ma'am.
Raise your hand.
State your full name.
Norris Eugene Dixon Jr.
Spell your middle name,
EUGENE.
and you are a junior.
Yes, ma'am.
All right. What is your date of birth?
6/17/1980.
80.
Yes, ma'am.
What is your current age?
40, ma'am.
How far did you go in school?
High school graduate, 1 year of college.
So you can read and write English without any problem. Is that correct?
Yes, ma'am.
Is this your attorney with you in court today, Ms. Zimbardi? Have you had an opportunity to meet with her and talk with her about each of these two cases?
Yeah.
Has she reviewed the two indictments with you so that you know what you're being charged with and how you're being charged in the indictment? Did she discuss with you your options of maintaining not guilty as your plea and going to a jury trial in either or both case, or entering a guilty plea and being sentenced today in either or both cases? Do you understand those options?
Yes, ma'am.
Do you need any additional time to talk to her today before I consider taking your plea? Have you been satisfied with her representation of you thus far?
Yes, ma'am.
Mr. Dixon, are you currently under the influence of alcohol or drugs?
Yes, ma'am.
Do you have any prescription medication in your system? Have you ever had any mental health illness treatment or diagnosis before? Sir, has anyone threatened you in any way or promised you anything to try to talk you into pleading guilty in this case?
Yes, ma'am.
Sir, I have in my hand and I'm holding up now the 1-page plea of guilty form. I use this with all defendants who come before me to enter a plea of guilty. Again, it's 1 page. It's front and back of that page. I'm turning it around to the back side of the page now. And about the middle of the page, there's a signature line for a defendant to sign. Does this line bear your signature? Signing here indicates to me that you've met today with Ms. Zimbardi and she's gone over everything on this form front and back with you. Did that happen?
Yes, ma'am.
Importantly, sir, number 9 on the form lists a number of rights that you have, like a right to a jury trial. Did she go over those list of rights and the waiver of those rights?
Yes, ma'am.
And did you understand that conversation?
Yes, ma'am.
I'm now going to go over the 2 indictments with you briefly, starting with the first one in numerical order, 20 SC 176822. This is the 6-count indictment. I'm holding it up now, turning it over to page 2. The top of this page in the middle, there's some text. At the bottom of the text is written in today's date, April 9th. 3 lines above the date, there's a signature line for a defendant to sign. Does this line bear your signature? Signing here indicates to me it's your desire today to enter a plea of guilty to this indictment. Is that your desire?
Yes, ma'am.
The next indictment is 20 SC 176869. This is the 1-count battery case. Again, looking at this indictment as I'm holding it up, page 1, bottom middle, same text right in the middle. It has at the bottom of the text today's date written in, 3 lines above the date. There's a signature line for a defendant to sign. Does that line bear your signature? Signing here indicates to me it's your desire today to enter a plea of guilty to the 1 count in this indictment. Is that your desire?
Yes, ma'am.
Sir, at this point, I'm going to be a bit repetitive of what your attorney has already reviewed with you from this form regarding a number of those important rights you have. It is the act of pleading guilty in either case or both cases which would waive these rights. So I repeat them with you before I come back to you at the end and ask you formally what your plea is. With respect to these rights, they apply independently to your two cases. You could take advantage of them in both or one or the other, or you could waive them in both or one or the other. With respect to each case, you have a right to plead not guilty and go to a jury trial, or you have the right to be represented by an attorney. If you cannot afford an attorney, you have the right to have one appointed to represent you at trial. At trial, you have a right to be presumed innocent of these charges, unless and until the state could carry its burden of proving its case against you beyond a reasonable doubt. At trial, you have a right against self-incrimination, meaning you have a right to remain silent at trial. No one can force you to testify. You, though, would also have a right to testify. So during trial court, the judge would ask you if you wanted to testify or remain silent, and you'd be afforded whichever of those two rights that you choose. You'd also have a right to cross-examine any witness that the state puts on the stand to testify against you. You'd have the right to subpoena and bring into court your own defense witnesses to testify for you. You'd have the right to admit into evidence any relevant admissible evidence in defense of your case. Sir, if you decided to go that route on either or both of your cases, that would be maintaining not guilty as your plea and going to a jury trial. If you got a verdict from any trial that you wish to appeal, you would have the right to do so and to be represented by an attorney at the time of your appeal. If you could not afford an attorney at the time of your appeal, you would have the right to have an attorney appointed to represent you during the direct or first level of your appeal. However, Mr. Dixon, if you enter this plea of guilty and I accept your guilty plea, then you're waiving all of these rights as to any case that you're entering a guilty plea to. Do you understand that? I also need to advise you that if you're not a U.S. citizen, entering a plea of guilty will impact your immigration rights. Do you understand? Speak up.
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I also need to advise you that if you have any other open cases that we are not resolving today, or if you pick up any cases in the future, you will have today's convictions on your record, and that could affect future sentencing in those type of cases. Do you understand?
Yes, ma'am.
I also need to advise you that if you wish to challenge your guilty plea by filing a separate habeas petition, you need to file your habeas petition within 4 years of any felony guilty plea, within 1 year of any misdemeanor plea. You understand?
Yes, ma'am.
Mr. Dixon, at this point, we're going to shift to the attorneys. I'm going to hear first from the state, who's going to go on the record with the sentence range for each of these offenses, the facts of your case, any conviction history they have for you, and what the state recommends on sentencing today. I will then hear from Ms. Zimbardi on your behalf with anything she may wish to go on the record with. At the end, I'll come back to you and find out what your plea is, then I'll sentence. Okay? Ms. Hilton.
Thank you, Your Honor. Your Honor, if this case were to go to trial, the state would expect to show, and I'm going to start with the 176-869 case, Your Honor, because that actually happened first in May of 2020. Your Honor, that incident occurred on May 26, 2020. Mr. Dixon is charged with 1 count of felony family violence battery, which has a sentence range of 1 to 5 years. He does have a previous aggravated assault family violence, which made this count a felony. On May 26, 2020, the victim, Nicole Smith, who is present in court today, they share 4 children together. On the day of the incident, they were arguing throughout the day. The victim went over to the defendant's house to get keys for a vehicle. When she arrived, there was another woman present at the house. When the victim got out of her vehicle, the defendant grabbed her by her hair, slammed her to the ground. After slamming her to the ground, he fled the scene. Officers were called, and they did observe abrasions on her hand. She did advise officers that there was an extensive history of DV towards her. The incident on August 25th, 2020, which is indictment ending in 176-822, did occur on August 26, 2020. In that case, Your Honor, Mr. Dixon is charged with 3 counts of aggravated assault. Each count is a sentence range of 1 to 20 years. 1 count of possession of a firearm by a convicted felon, which is sentence range is 1 to 5 years, and 1 count of possession of a firearm during the commission of a felony, which is a sentence of 5 years to serve consecutive to each count.
You said 1 count of possession by, I think there are 2.
There's 2, I'm sorry. We're going to be nullifying that second count, Your Honor.
Okay.
On that incident day, the defendant went over to the victim's house to pick up his son. This is not a son that they shared together. However, Ms. Smith is taking care of one of his other children. However, she did not allow him to see this son. A physical altercation occurred between them. At this point, the police were called. The defendant left the house, and Ms. Smith followed the defendant to a house on Dargan Place Northwest, which is Atlanta, Georgia, in Fulton County. The victim, her daughter Crystal Smith, and another daughter that she shares with the defendant, Natalie Dixon, were all in the car. They waited at this home until police came. While waiting outside, initially the victim told officer that the defendant came out of the house with a gun. She advised that initially the gun was down by his side. He then raised it at the car and in the direction of the car that they were in. Once the defendant held the gun up, the victim left the location and spoke with officers at a different location. The state has since spoken with Ms. Smith. She's now contending that there was not a gun in this case. However, based on her initial reports to the police, as well as her daughter saying that the defendant had a gun as well, we are moving forward with this case. Mr. Dixon's felony convictions, Your Honor, he has a conviction for BGCSA from 2001 out of Fulton County. He has a subsequent BGCSA in possession of a firearm by a convicted felon out of Fulton County 2003. He has a third BGCSA out of Fulton County from 2005, another BGCSA out of Fulton County from
6 years flat today, just total.
Say that last 6 years, what?
Just 6 years as of today.
6 years as of today.
Yes, Judge.
Anything?
It wouldn't apply anymore because Judge Tucson is,
We can't hear you.
I'm sorry, the return to, I don't see it.
SC 150440.
How much time, Madam Probation Officer, on the other probation matter?
I calculated 5 months and 14 days. It was a Judge Downs.
Recommendation?
Yes, Your Honor. As in the first case, the state's recommendation is 5 years to serve 1 year, commuted to the time that he's with 20 SC 176822. No violent contact with Nicole Smith, no guns, no other weapons. Also, after 5 years of successful probation, balance can be suspended. As the count 2 aggravated assault, that count will be null pro. Count 3 aggravated assault will be the same as count 1, 10 years to serve 1, community time served, balance on probation.
What? For that second case?
1, community time served with a consecutive 5 years on suspended sentence.
Okay, so count 4, you said 5 years consecutive to serve. Is that not what your recommendation is?
Yes, count 4 is 5 years to serve consecutive or suspended.
So you just said the global was 10 years to serve 1 year, followed by consecutive 5 years suspended.
Yes. Am I not saying that right? Okay.
So it's either suspended or it's to serve.
5 years suspended. This is count 4 consecutive. The
Okay.
consecutive count 4 is 5 years suspended.
Who knows, Ms. Hilton? We've both been doing this a long time, but who knows? But it's important for clarity. So the global sentence is 10 years to serve 1 year. That 1 year is commuted to time served. Balance of 9 years on probation, followed by consecutive 5 years that are suspended. Okay. Ms. Zimbardi, let me hear from defense.
Yes, Your Honor. Can you hear me okay?
I can.
Your Honor, we are asking that you accept the negotiated plea. We are also asking to enter that plea under Alfred versus North Carolina. As you heard in the aggravated assault case, Ms. Smith has said that Mr. Dixon did not have a firearm, that she was mistaken. It was, she realized afterwards that it was a cell phone that he had in his hand. Your Honor, at the time, and I've spoken with Ms. Smith at length, she has said in both of these cases that they did have an extensive argument, that she was mad, and that was part of why she called the police. We believe that there is some that Mr. Dixon could benefit from anger management. That's part of the discussions with the state. However, I don't believe that either of these incidences arose to the level that was originally alleged, and that was part of the discussions with the state in the time served offer. As to the battery incident, that incident as well was, Ms. Smith has said, rose to the level of an argument. It did not go past that point. Mr. Dixon was actually not arrested that day for that incident. He was not arrested until much later after the second incident. However, Your Honor, they have been in a long-term relationship. They do have children together and have been in that relationship this entire year, despite these incidences. And Your Honor, Ms. Smith is interested. She is here on his behalf, wanting to support him and be with him moving forward, hence the no violent contact stipulation. So Your Honor, we would just ask that you would accept the negotiated plea, that you would allow him to enter the pleas under Alfred versus North Carolina. Mr. Dixon understands that he does have the ability to go to trial and prove his innocence. However, he at this point is interested in taking these pleas and moving forward with his life.
How old was Crystal Smith at the time of the incident?
Crystal at the time would have been 18. She was born in 2002.
So has she recanted with respect to the gun being present?
We have not heard from Crystal that she's recanted. Her mother told me today that, but as Smith, I do not know if we've spoken to her directly here. She's recanting about the gun at this point.
What is the recommendation on the probation cases?
Your Honor, the recommendation on the probation cases is to, for 17 SC 150440, revoke the 6 months that he's been in and close that case out.
Okay.
And for 17 SC 155880, revoke 6 months and reinstate the balance.
Judge, is that, or Ms. Hilton, is that to be commuted to time served, credit for time served, or just to serve as of starting today?
Commuted to time served.
Thank you.
Well, how much time has he served?
I think because when the warrants were served on him,
I have that he's been in 163 days as of the publishing of the calendar.
I think it's close to 180 now.
183 days now, or as of yesterday, 183 days.
Sounds like he's served the 6 months. Anything else for defense?
I will just say, in my discussions with Smith, she did tell me that that Crystal Smith had written a letter, and that she was actually emailed me that letter, and I believe she had emailed it to the state, but I'm not positive on that. And in that letter, she does say that he did not have a firearm.
I have not received that letter, Your Honor. I'm not saying it wasn't. I don't know if it's emailed to the state side.
All right. All right, Mr. Dixon, having heard from the attorneys, I need to hear from you with respect to your plea. I'm not going to accept an Alfred plea on these cases. I'll accept a not guilty plea and we can go to trial, or a guilty plea. That's your choice. So with that, 20 SC 176869, the 1 count family violence battery, what is your plea?
Yes.
With respect to 20 SC 176822, what is your plea to the 6 counts in that indictment?
Yes.
I accept your guilty pleas. I do find there's a factual basis to support them, and that you're entering today's pleas freely and voluntarily with full knowledge of your rights and those you waive in entering them. I will agree to the Senate's recommendations with a few additions regarding the probation. With respect to 20 SC 176869, the 1 count battery, 5 years to serve 1 year. That 1 year is commuted to time you've served. The balance is on probation. Conditions of your probation: you must complete the 12-week anger management program, but you must do that within the first 6 months of your probation. I don't want probation running 3 years and you haven't done that. I think that's a good program and it would serve you well. So you are ordered to do it within the first 6 months. If you haven't done it, then the probation department can issue a warrant for your arrest. You would have no violent contact with the named victim in that indictment, Miss Nicole Smith. That sentence will run concurrent with 20 SC 17682, count 1, 10 years to serve 1 year. That 1 year is commuted to time you have served, balance on probation. Special conditions of your probation, you were to have no violent contact with the named victim in count 1, which is Nicole Smith. You were to have no guns on you or in your possession. Count 2 is null pros. Count 3, 10 years to serve 1 year, commuted to time served, balance on probation, no violent contact with the named victim in that charge, which is Crystal Smith, no guns. That runs concurrent with count 1. Count 4, 5 years consecutive but suspended. Count 5, 5 years to serve 1 year, balance of 4 years on probation, concurrent with count 1. Count 6 is null prost. All violations can be handled through POM up to the full extent of the law. With respect to 17 SC 150440, the probation case, I'm revoking 6 months, which you have served, and it'll be closed. With respect to, we'll say commuted to time served if there's any issue with a few days. 6 months commuted to time served and closed. With respect to 17 SC 155880, revoked 6 months, 6 months revoked or commuted to time served. The balance on that one is reinstated. Please check the POM for that sentence, Madam Probation Officer. Any new violations up to the extent of the law can be handled via the POM program. Anything else for the state?
Nothing else to say, Your Honor.
For the defense?
No, Your Honor.
Good luck, Mr. Dixon.
Thank you.
You can take him back.
Judge, I'm sorry. Do you do reporting instructions?
Oh, I'm sorry, Mr. Dixon, not quite. I always forget probation. Why do we not have our screen on this morning? Can you
I
see on
see
your
it.
screen right here? Okay. Okay, Madam Probation Officer, going to give you reporting instructions for probation. Go ahead.
Mr. Dixon, I have the last address I have on file for you is a Rocky Valley Drive. Is that still accurate?
Yes, no, ma'am, it's not. It's the mailing address where my paperwork been sent to this day. It's Miss Smith's address. I will be staying with her now. That was my old address in Decatur. I'm no longer staying there no more.
Do you
Okay.
know where you will be
I
staying?
don't know the address by heart.
Okay. Is it Fulton County?
Yes, ma'am, it's Fulton County.
He's in
Okay.
Fulton.
I've been getting mail. My court date's there.
Okay.
I've been sending my mail for my court date there.
She'll give you information. Go ahead, Ms.
Yes.
Probation Officer.
So just for, I'm going to give you reporting instructions to report to our field office in Fulton County. And that is 276 Memorial Drive Southwest. And that is in Atlanta. And the zip code is 30303. And the report date is August 5th. I believe you should be out of custody at that point. And then that'll be at 9 a.m. in the morning. And you'll go through your intake process and return to probation on your other docket. Your sentence will start as today, but the intake will be on
We
August.
can't hear you. We can't hear you.
You will be, you'll have your intake on August 5th, but your probation starts today and you're reinstated as of today. And just provide your updated contact information when you report.
Yes, ma'am.
August 5th is your report
August
date.
5th, 9 o'clock, 27. Yes, Judge, 276 Memorial Drive, Southwest.
Yes, ma'am.
That's all I have. Thank you.
Thank you. Yes, Mr. Dixon, before you go, Mr. Dixon, she's going to give you the reporting instructions in writing. I'll give these. Okay. Yes, thanks.
And I believe that includes mine as well. I may stick around and but otherwise.
All right, that's fine. Thanks.
Oh, no.
Are we ready on Mr. Hadley's case?
I believe that, I expect with Mr. Kanye, I don't believe that Mr. Hadley can start petitions for his first offender status and his probation in this case. So we can go forward if he's been served the petition.
All right, what say the state?
Yes, Your Honor. It's my understanding in speaking with probation this morning that no petition had been served yet on Mr. Hadley. I would point, just for the record, because I know the notes in the calendar indicate that the last time we were here, the officer did not show. He is here today. He was we were ready to go forward should the petitions have been served. But it's my understanding in looking through the record that there is no record of service of petition that's been filed. And in speaking with probation, I don't believe that a petition has been served on him.
Well, these were set for the purpose of a probation revocation hearing, and it was based on the 3 warrants. He was on the calendar last time for that purpose. How has he not received adequate notice of a basis of a probation revocation based on that? Ms. Hanson, this wasn't raised last time. There was no issue raised with respect to him not getting notice.
We can go forward on revocation, but
Mhm.
the first offender can't vote without the petition being filed and served.
Okay. So what is the state going to be requesting for these?
So based on that, and obviously based on Ms. Hanson's representation, the state would be asking to revoke the balance of probation that he currently has. And I believe, the end date, which is October 27th, 2023. So I think it works out to about 2.5 years.
But then we'll go forward on that with the caveat, as Ms. Hanson has objected to, no revoking of the first offender status. Do we need a hearing?
If I could just have a moment to speak with them, I would appreciate it. I think it's glad to have an opportunity to for a client being ready.
All right.
I'm just a little lost.
Okay. Are you not here, Ms. Zimbardi, on the Jackson case?
I just took the attorney on it, so-
You might wrap up in.
It's fine. I just she said whatever y'all have worked out is fine, but I just didn't want her to be excused if y'all hadn't figured out what you're gonna do on Dan Jackson. Are you ready on Corwin Monson, Ms. Gladden?
Phil and I need to speak to Mr. Munson. I have 2 appointments.
That's fine. Let me just step down, and let the attorneys talk. That's fine. Okay.
This is for codes for both of our states. We're on lockdown all day yesterday.
Oh,
And
okay.
before that, Secure has got me on with invitation, so I had all this stuff figured out and didn't quite work out.
Well, thank you. Good to let the court know that you're trying. Deputy Palmer, just let them both have time to talk to their clients so I can come out and just handle everything. So if they need a shift time in the back, that's fine. Just send word through Ms. Ventry when you're ready.
Saying something. I don't know how to turn it up. I don't think you can turn it off.
I'll ask. Oh. Oh, what are you doing? I'm sorry.
No, I was just letting you know.
Oh, yeah, criminal, all criminal. Ms. Glenn? Oh, yes, thank you.
Stipulates, I would say 18 months. That's the incentive. That's like,
right?
I mean, like, because at that point, you could also raise that.
She's the only one so far that has talked from Zoom. Yeah. So I don't know if it was just in one computer or is it from here? Miss Sims,
Yes.
we're just trying to see if we can hear, we could hear another person on the Zoom very well, so we wanted to know how.
Can you hear me okay?
Sam, are you, the volume turned on there for your, on your end?
Can you hear me okay?
Yeah, I can hear her. Maybe it was Miss Corwin. I can hear you, thank you. Yeah, it wasn't Miss Corwin. Yeah, we know that. I was just trying to see if Miss Sims was audible, you know, when you hear her.
You can go back to what you were saying.
Miss Corwin, are you there?
Yes.
I wanted to hear you. See, but we didn't know the volume, because we had a hard time hearing you, so we're wondering if it's the volume on your end.
I can turn it up. Is that better?
So you can go up a little more because, yeah, we had a very hard time hearing you.
That's as high as my volume goes on my.
That's better though. It is better.
Okay. All right. I'll try to. I'm just gonna yell.
Thank you.
You're welcome. Sorry.
The one she gave me didn't have. Yeah.
She said,
Okay.
I got it. Yeah, well, Wait. I didn't. Yeah, so she likes for me to get it. I didn't know. Okay, well, that's fine. Oh, not a big deal. What's there? Yeah, I just needed that. Got a couple minutes left. What's your name again? Yes.
Supervisor that came in here raising the line.
I'm Hadley.
He's gonna be coming out. Yeah. He's next.
This love. What is love?
You gotta do it the hard way.
Yeah, but that's like. That's what May, yeah, May 6th.
You have to shut down the jail every time somebody spills water on the floor. People don't make the phone calls.
I'm gonna bring it back.
Last one.
No. You want to have a hearing? Interesting to see how they catch Okay, we're gonna have a hearing. Oh, you talking?
Oh, no, I was, okay.
I was gonna try to, but depending on when we get done, I know. If I can get through before you go. I know.
Yeah.
I wonder what actually happened yesterday. Yeah. Is Dixon still back there?
Everybody's back.
Okay, good. We need to update his probation info.
I'm listening. I'm good.
Dixon. She said August 6th or May 6th. I was thinking that was really far out there. Unless he's gonna be.
Yeah, sorry about that. I had a brain.
Oh, it's okay. Yeah.
It's Friday behavior.
Before-
I was like, I just realized it after. I'm like, and I really wrote it down too. And I'm like, that's not right. So, thank you.
You're ready for the summer to be over.
I know.
I wanted to talk to Rhapsody about the guy who's going to drug John Harper because drug groups lifted the hold of the net, and for some reason Glover at the jail that they lifted the sentence on. We've never done that in the past. Drug courts always just and then put it back on. Exactly. Yeah. So I responded, I'm pretty sure this is how that works. They're doing all kinds of great shit. And the thing is, I don't know what actually the sheriff or just being lazy. No. So.
Well, now come to order. Remain seated.
Do you all have a preference on which one we take up next, either Mr. Hadley or Mr. Jackson or Mr. Monson? No preference. All right, Mr. Hadley's up next. Ms. Hanson, are you ready?
Yes, Your Honor, we're going to go forward with the hearing.
Okay. Let's bring out Mr. Hadley. All right, good morning, Mr. Hadley. I'm Judge Ellerbe. I have your 3 probation cases on my calendar today for a hearing on a request to revoke probation on those 3 cases based on a January 4, 2021 alleged new offense for indictments 19 SC 166,577, 19 SC 167,628, and 19 SC 171,921. How many witnesses for the state?
1 witness, Your Honor.
Call your first witness.
Yes, Your Honor. The state calls Officer Cannon Parker.
All right, officer, if you please come up to our witness stand. Once you get up here, if you will remain standing, allow the deputy to swear you in before you take your seat.
First name is Cannon, Kannon, last name Parker.
Go ahead.
All right, good morning, Officer Parker. Where are you currently employed?
Atlanta Police Department.
And what are your duties with the Atlanta Police Department?
To enforce the law.
Are you assigned to any specific units or areas?
I am assigned to Zone 2 Warning Watch.
Are you post-certified?
Yes, sir.
On January 4th, 2021, were you employed by APD?
Yes, sir.
And at that time, were you post-certified?
Yes, sir.
On that date, did you respond to any sort of incident at 250 Far Road Northeast in Atlanta?
That is correct.
And is that, what county is that in?
Fulton County.
So what were you responding to that day?
It was a 911 call called in by the concierge at 250 Far Road, the condominiums there. Concierge said he's.
Response?
Your Honor, I would just, again, I think it's not going for the truth of the matter asserted, rather the officer's impression at that point.
All right. Any response to the exception hearsay?
Yes, Your Honor, Ware versus State 289, Georgia Appeals 860, 2008 case, provides that there is not, that hearsay is inadmissible. It's also under Brown versus State 290, 1, 2008, holding that a written informant did not testify. His statements were not competent to show that certain calls were made. Therefore, an out-of-court statement by a witness often heard is hearsay. If the state is not operating the truth of the matter, so there are ways to get at that information or to get at the reason for the officer being present.
So he made, though, you're making a general hearsay argument. Was that Ware case or the other case you cited a police officer testifying as to a call? What was the fact?
The Brown case, Your Honor, was an officer who was testifying to information from an informant. He was testifying to statements made by an informant. He was a party to a phone call. The officer was actually present during the phone call and heard the phone call. However, the informant's statements about the contents of the phone call were not admissible, even though the officer actually heard them was present.
Was there a present sense impression argument or ruling on that exception?
Not that I'm aware of. What that court held was the statements weren't competent to show because hearsay does not have any evidentiary value. The Ware case concerns confrontations. When the defendant Sixth Amendment right to confrontation and holds that the court has to make a two-pronged finding as to whether it's admissible in the confrontation. The first prong being that the minimum protections of due process, including the right to confrontation and cross-examination of that witness, is available, which is not. This officer was not present, did not see what happened. He's talking about a 911 call that I don't think he heard. And 2, the second prong is that the state has to find that there's good cause for not allowing or for not providing that witness and allowing the defendant to confront witnesses.
All right, any state response?
No, Your Honor, as noted, this is being offered, again, not for the truth of the matter asserted, but rather for the impression of the officer essentially going to that location.
Did he hear the 911 call?
It's my understanding, Your Honor, no.
Do we know who the 911 caller was?
We do, Your Honor.
Okay. I want to sustain the objection.
And so, officer, without saying what anybody told you, we'll stay away from that. When you arrived at that location, what type of building or location is it?
It is a parking deck connected to the condominiums.
And as you enter, you see or hear anything?
Yes, I heard the car alarm going off to a Jeep Cherokee in the parking garage.
And were you able to see who is in that Jeep Cherokee?
Yeah, I saw the defendant getting out of the Jeep Cherokee on the driver's side.
And you said you heard an alarm, is that correct?
That is correct.
And he was, when you say he was getting out of the driver's side, was he actually in the vehicle?
That is correct.
Were you able to determine who that vehicle belonged to?
Yes. This is.
Wait.
That was my car.
Need to see if you can overcome the objection. So I sustain it at this point.
Your Honor, I would, if I may.
You may.
I'm not offering an out-of-court statement. I believe that it's not a statement of an individual, therefore it wouldn't fall within the hearsay category.
Well, then why don't you ask him some foundation questions?
Okay. As an officer, are you able to are you able to determine who vehicles belong to with a system that you have?
That is correct.
And what type of system is that?
GCIC.
And were you able to do that with the vehicle in this case?
Yes, that is correct.
And who are you able to determine that vehicle belonged to?
Overruled. You can answer.
Yeah, it's Mr. Timothy Osborne Jr.
You indicated that that the defendant was there. Who did you determine the defendant to be?
The owner of the vehicle. He had keys to the car to be able to turn the car alarm off.
So I'm with respect to the defendant, were you able to determine who the defendant was?
As far as the owner, no,
No.
He was not the owner of the vehicle.
Okay. You indicated that Mr. Hadley was in the car. Did he make any statements to you?
He said that it was his cousin's vehicle.
At that time that he was there, was the alarm still active?
Yes, that is correct. And the door was still open to the vehicle.
Did you ask him if he could turn the alarm off?
I did.
Was he able to?
No, sir. He did not have any keys or anything.
Who was able to turn the vehicle off?
The actual owner, Mr. Osborne.
What did he do? And without saying anything that he said, what did he do?
He turned the alarm off and said no one else was authorized.
Don't tell me what he said.
Yes, ma'am. But basically, he had the key to his own vehicle. He closed the door.
And he turned the alarm off.
That is correct.
Were you able to determine what Mr. Hadley had in his possession?
He had multiple people's IDs and he had a screwdriver that's used to actually break into cars.
And
from my knowledge.
And that was going to be my next question. Have you had, do you have any knowledge or training about how screwdrivers are used?
Yes, that's correct.
And how are they used sometimes by individuals?
Either to pop locks or to break the ignition inside vehicles.
Were you able to, and do you see the individual that you encountered there in court today?
Yes, I do.
And where is he? And if you could describe what he's wearing?
He's sitting down here at the table with a blue jumpsuit on, Fulton County intake.
Your Honor, let the record reflect that the officer has identified Mr. Hadley.
So the record will so reflect.
Did the owner of the vehicle have keys to turn the alarm off?
That is correct.
Was he able to turn the alarm off?
Yes, sir.
Was Mr. Hadley at any point in possession of those keys?
That's a negative. No, sir.
No further questions, Your Honor.
Cross.
What do the keys look like?
They look like Jeep Cherokee keys.
What does that look like?
Keys.
So is it kind of key that you put in like a house or a car door, or was it a key fob?
He had keys for the Jeep Cherokee. I think that he had the button to turn the alarm off, and then he had an actual physical key that goes into the ignition.
Do you remember specifically, or you said you think? Do you remember that specifically?
I know if he was able to turn the alarm off, that means he had a button to turn the alarm off. As far as the key, I do not remember.
Did he get into the car, Mr. Osborne?
No, he didn't. He looked inside the vehicle to see if anything was taken, but he closed the door once he turned the alarm off. This is all on my body camera, by the way.
Okay, do you have your body camera with you today?
That is negative, ma'am. You can get that.
Well, did you provide it to the district attorney's office?
No, ma'am, I do not.
But you provided your report, correct?
Yeah, that's correct.
And you received a subpoena to be here today, correct?
Yes, ma'am.
On the 4th of January, 2021, 1 o'clock in the morning, about that. It was cold, correct? Fair to say?
Yes, ma'am.
Okay. And this was at a parking garage. Was it on the first floor, second floor, third floor?
It's just the 4th floor.
Okay, the 4th floor is at the top, bottom, middle.
I don't know how many floors it is, but I know that was the 4th floor. It had to be in the middle or whatever.
Was anybody with you?
I was by myself at the time until other officers arrived.
Were the other officers present when you were encountering Mr. Hadley?
They came after I got him in custody.
Okay. So pretty much up until the moment of arrest, you're by yourself.
That is correct.
All right. When, what caused him to get out of the car? Was he already getting out of the car when you got there, or did you?
He saw my patrol car and walked away very fast.
Okay.
After he got out of the.
So let me ask you this. Did you then stop him?
That is correct.
Right. When you stopped him, did he have the backpack on him, or was the backpack in the car?
The backpack was on his back.
And inside the backpack was, you said, some clothing, right?
That is correct.
The clothing, did they appear to be men's clothing, consistent with men's clothing?
He had a lot of different clothes in there.
Did he have any baby clothes in there,
I don't remember, ma'am.
or any dresses?
I don't remember.
Was there anything inconsistent with clothes that he could wear that you remember?
People can wear all different types of clothes. Like I said, I don't remember what type of clothes he had in there.
Well, yes, but you can't wear a size 2 in a women's dress, correct?
That is correct.
All right. So were there any clothes that Mr. Hadley, by his appearance, could not wear?
Objection as to relevance.
Okay. No, I don't
Wait.
remember what kind of
He
clothes was in the
said
back.
he doesn't remember the type of clothes, so I'm gonna ask you to move on.
The screwdriver, where was that?
Screwdriver was inside the book bag.
Okay. Any other tools, wrenches, hammers, anything like that?
No, ma'am, just a screwdriver.
And as far as the identifications go, there were 3 identifications, correct?
That's correct.
And did you ascertain in any way if those people were in any way related to Mr. Hadley?
He gave no answer for those IDs. So he didn't know how he got them.
Okay. And was there any kind of credit cards or wallets or anything inside the backpack that you remember?
No, ma'am, just people's IDs.
Any keys?
No.
Anything else that you can recall specifically being inside the backpack?
Just clothes and IDs and the tool that he had.
Okay. Now, were there marks on the Jeep Cherokee that were consistent with breaking and entering into the vehicle?
No.
Was there any paint transfer on the screwdriver to indicate that it had been used to break into the vehicle?
No, ma'am.
Did Mr. Hadley have any paint or anything on his body that indicated that he had forced entry into the vehicle?
No, ma'am.
Was he homeless?
Did you make any determination as to whether he
Objection,
was,
Your Honor, calls for speculation.
Sustained unless you can lay a foundation.
did you find any idea, Mr. Hadley, for him?
No,
Did you ask him where he lived?
no, ma'am.
Do you have your police report with you?
Yes, ma'am, I do.
Okay. And forgive me if you said this on direct or even on cross, but you said that he was walking away from the vehicle when you approached?
Mhm.
Okay, all right. I just wanted to make sure you didn't say he was running or running for the door or anything like that. He was walking away from the vehicle when you approached, correct?
Yes.
Okay. Did he struggle when you approached him?
No, because the way I approached him,
What'd you do?
my patrol car was pretty much right beside him when he was trying to walk through the parking garage.
Okay.
So I got up pretty close.
You could have run, right?
I mean, he could have.
Yeah. All right, I think that's all I have. Thank you.
Be direct.
Just briefly, Your Honor. So when you first arrived, where was Mr. Hadley?
He was inside the Jeep Cherokee.
And then at that point, you mentioned, was the alarm going off at that point?
It was actively going off when I first came inside the parking garage.
You mentioned that he then walked away. Is that correct?
That's correct.
At that point, was the alarm still going off?
Yes, sir.
Did he close the door to the vehicle at all? Or
No, he did not.
so he was walking away and left the vehicle door open?
With the vehicle door open and the alarm still going off.
No further questions, Your Honor.
Any recross? Any additional, any reason to keep this officer here?
No, Your Honor, the officer may be released.
Okay. Off the record for just a minute. Officer, you received a summons to be here last time. Why weren't you here?
I was on sick leave for 3.5 weeks.
But you still received the subpoena to be here via the internal system?
No, ma'am. It didn't come to my email until like later on.
Make sure to follow up, and have a system in place because the ADA reported that it had been delivered. So we don't want to be issuing any contempt notices when you didn't receive it. So just make sure that there's a process in place. So
Yes,
that
ma'am. We've been having problems with the system as far as with our subpoenas coming out.
Say that again.
So we've been having problems with the system as far as subpoenas being sent out.
Okay. Do what you can to get that corrected because we could send out contempt notices for officers. And we certainly don't want to do that, especially if you're on sick leave and didn't get it. Okay.
Okay, I copied it.
Thank you. You're excused. Any additional witness for the state?
No, Your Honor.
Any defense witness? Okay. You want me to review with him his rights, Ms. Hanson?
Yes.
All right, Mr. Hadley, are you finished with him?
Yes.
Okay. Mr. Hadley, you have a right to testify if you'd like to do so now. And that's your choice. It's not Ms. Hanson's, it's your choice. It's not anybody else's choice. Do you understand that? You also have a right to remain silent and not testify. Do you understand that? All right. Do you understand that if you choose to testify, that not only will Ms. Hanson be able to ask you questions, but the assistant district attorney will also be able to ask you questions? Do you understand that? Have you had a chance to talk to Ms. Hanson about your decision on whether or not to testify?
Not really.
Okay, well, why don't you take a little more time and talk to her about whether or not you want to testify? Then I'll hear from you on whether or not you want to testify, okay? Do you want to go in the holding cell or?
Yes, if we can just stand there, that'd be great.
Yes. I'm gonna just step down. We've always assigned him here. This is yours. After you're done, it's to float you around. Yeah. Yep.
Well, now come to order. Remain seated.
All right, we're back on the record. Mr. Hadley, I've given you additional time to talk to Ms. Hanson just to get her input and advice on whether or not you testify. But again, it's your decision on whether or not you testify. So let me know, do you wish to testify or not? Okay, well, we're going to have you come up to the witness stand. The deputy's going to walk you up now. All right, let the deputy swear you in before you take your seat.
Do you swear or affirm that you want to give the court today the whole truth and nothing but the truth?
Yeah.
Take a seat. State. Swear your first name. Speak loud.
DRESHAWN HADDLEY.
H-A-D-D, two Ds?
Yeah, LEY.
H-A-D-D-L-E-Y, okay. Go ahead.
Mr. Hadley, how old are you?
25.
And you were arrested, or you've been a resident of Rice Street, Fulton County Jail since January 4th of this year, correct?
Well, I had just got up out of there for another case that I had got dismissed.
Listen to my question. Are you currently in custody?
Yeah.
And you've been there at this point since January the 4th, correct?
Mm-hmm.
All right. Where did you live on January the 4th?
I was actually, before I was staying, I had went back to Mexico. I'm from Mexico. I'm a Mexican citizen.
You were in Mexico on January 4th?
Yes, and I had they had came and got me and brought me back over here. Some people, some bounty people or something like that. They had tried to come talk to me and tried telling me that I had to come to America. I wasn't born or raised here in America. So I've been through this process before where they had to actually deport me back to Mexico.
Okay, Mr. Hadley, I'm asking you to be responsive to my question, okay? Listen to
I
my
hear
question.
you.
Okay, all right. So on January the 4th, were you arrested by the officer that you just saw testify?
Yeah, he pulled a gun out on me and
Okay,
threatened to shoot
my
me.
question is, were you arrested? We're gonna get there, okay? On January the 4th, were you at that location? Were you in a Jeep Cherokee on January the 4th, 2021?
No,
You were not inside of a Jeep Cherokee on that date.
no.
Where were you?
I was walking around and I had accidentally bumped into the car and the alarm went off. And
What kind of car did you bump into?
it was a white, I don't remember exactly what type of
Oh, that's okay.
what type of car it was, but I had actually bumped into it and the alarm went off, and I had seen an officer pulling up on me,
Okay,
and he had
hold on. What were you doing in the parking garage in the first place?
I needed somewhere to go because I had got stranded here in Georgia.
Why the parking garage?
Because that was the only open place at the time. No other businesses were open at the time when the police had pulled. It was like
Okay,
12 o'clock at night or something.
so the police pull you over. Do you have are you carrying anything?
Yeah, I was carrying my backpack. I had my phone. I had a phone because I had just called the Atlanta Police Department to see if I could get some assistance on going back to getting back to Mexico.
Okay, so you had your phone. What else were you carrying?
I had some changing clothes. I was going to try to change I think I had my toothbrush, my regular, I hadn't planned on being over in America for that long of a time. But since this had happened, I've been over here longer than what I expected to, but hopefully I can get it all situated out so I can get back to where I was going.
Listen to my question. Did you have anything else on you?
I had a screwdriver on me because I needed a weapon, just in case something had happened. Nothing usually happens, but I had something on me, just in case I needed a handy tool.
Where did you get the screwdriver?
I had found it in a toolbox somewhere. I don't remember exactly where I had found it at, but
What kind of screwdriver was it?
it was just one that was kind of messed up a little bit. It wasn't like.
Do you know anything about whether it was flathead or Phillips head? Know anything about those?
I think it was a flathead or something like that.
So what did you ever use that screwdriver to break into any cars?
No, actually, nope, I never. Nope.
Okay. Did you ever break into any cars in that parking garage?
Nope.
Did you steal any
Objection leading.
Sustained.
What did you do while you were in that parking garage? If you can.
I was trying to find somewhere I could, sit down and rest at because I had just bought this new outfit and I didn't want to get my clothes all dirty. So I was trying to find somewhere I can sit down at for a quick second until I can,
Go ahead.
Until I can get myself situated, without having to sit on the ground and all that. So I was trying to, find my way around, but I couldn't make nothing happen. So on my way out the parking garage, I was trying to sit on top of the car. I was trying to sit on top of on one of the cars so I wouldn't so I wouldn't have to get my brand new outfit I had just got dirty. I was just trying to make a quick phone call real fast. I had just got off the phone with the police department, but they had said they couldn't do nothing to help me with finding the
My
with
question
finding the
was,
passport.
my question was, what were you doing in the parking garage? Is that it?
I was trying to, it was cold, so I was trying to find. It wasn't the warmest place I could find, but I was just trying to find somewhere I could, sit and get warm at for a second until I could find my way back home to Mexico,
So
where I'm originally from.
did you have any money?
Yeah, I had about $50 on me, which the officer took, and I wouldn't be receiving back, even if I would have got released.
Okay, so when the officer pulled you over, when the officer came up on you, what happened? What was the encounter with the officer?
We had a dispute because I had a few items on me, and he had pulled his gun out on me like he was gonna try to rob me. I had my brand new phone on me. I had a few dollars on me. It wasn't a lot of money. I think it was only like $50 or something like that. But he got that though. He ain't mentioned that when he was saying all this. He got my brand new phone and my $50. But that's a whole nother story right there. But
So what happened after, well, at this point, he stopped you. Did he arrest you? He put you in handcuffs.
yeah, he had pulled his gun out on me like he basically said he was gonna shoot me if I ain't come off of what I had. He went straight in my pocket. It was really like basically a robbery, and then he tried bringing me to jail to try to make it seem like just try to make some extra out of what it wasn't. And then so he can get away with what he had took from me in the first place. He got my backpack and everything. I don't know what he want with my underwears or nothing like that. I don't want to know neither. But he got my changing clothes, all this. But now he's trying to talk about some 10 years up in jail and all this. Like to try to get me to forget about my property that I had came up in here with. I still remember it though, but I guess when I get released up out of here, I won't be getting it back. So I ain't tripping about it. I got away with my life from a man holding a gun up to me, threatening to shoot me. So I mean, that's probably why he didn't come to court last time, because he knew he was in the wrong in the first place.
Focus you again on the parking garage. Did you get arrested? Did he put you in handcuffs as well?
Yeah, he put me.
Did he take you to jail? Did somebody take you to jail that was an officer?
Yeah, and I had a little bit of weed in my pocket. So when I was in the back seat, I was all nervous and everything. So I took the weed out my pocket and I had lit it up, which pardon me, because of my, I got bad nerves and I take medicine for my nerves. So I had lit the weed up and took a few puffs out of it before he would have shot me or something like that. But I really did get nervous because I've been in this situation before where I done got pulled over and taken into custody, and they done took my property.
I'm going to focus you again, okay? Did you hear the officer testify today about any marijuana?
No, but he got my.
And did you, did you tell him anything about the screwdriver or the things that were in your possession?
No, he went straight for my pocket. Like he knew what he was going for.
All right, Mr. Hadley. Do you have any mental health diagnosis, Mr. Hadley?
Not that I know of.
Any physical health issues that you're aware of?
My hand is kind of messed up right now. I had just got into an altercation while I was in jail. I got stabbed while I was in there, but that's about it, right? That's about it, But I ain't got nothing.
All right, that's all I have, Mr. Hadley.
Cross?
Yes, Your Honor. Good morning, Mr. Hadley.
Good morning.
Just going to ask you some pretty simple yes or no questions. So
Well, I object to that frame, Your Honor. He's entitled to explain. It requires explaining if he wants to.
I'll rephrase. I'm going to ask you some pretty simple questions, Mr. Hadley. On the day you were arrested, it was early in the morning, wasn't it?
No, it was it was like 12 o'clock midnight.
And you said it,
12.
and you said it was cold?
Yeah, it was kind of cold outside. I had on my coat, my gloves, and everything.
And again, just Matt, I'm going to ask my questions. You said you bumped into a car. Is that right?
Yeah, I had accidentally. When I was walking in the garage, I had accidentally ran into a car. I had been nervous and I had been stressed out from when I was in Rice Street last time because
Mr. Hadley, that wasn't my question. My question was had you bumped in? Did you bump into a car?
yeah, I had accidentally bumped into one of the cars in the garage and the alarm went off.
And you were also in that car, weren't you?
Actually, no, I didn't enter the car, no.
But the door was open, wasn't it?
I don't remember. I kind of blacked out after he pulled the gun. I don't remember no door being open to the car. No.
What color car was it?
I think it was a whitish grayish type.
It wasn't your car, was it?
It wasn't a car, it was a truck.
It wasn't your truck, was it? And Mr. Hadley, make sure you pull your mask up over your nose.
My family had a lot of, I had inherited a lot of money from my family. I had bought a lot of cars when I was younger.
Mr. Hadley, that wasn't my question. My question was, that wasn't your car, was it? Or wasn't your truck, was it?
Well, no, and I hope whoever car it was forgives me for bumping into it on accident.
And you were seen inside of that car, weren't you?
I don't know if anybody was watching me while I didn't see nobody watching what I was doing. I didn't go inside the car. Yeah.
And you said that you had a couple items with you, didn't you? A screwdriver? Is that right?
Yeah.
And didn't you also have some identification cards with you?
Yeah, I had my family's identification cards. I had been holding on to them for them while they had some business they had to take care of. That's what I was saying. I knew a lot of family in the area, so I wasn't sure if the car had belonged to. I wasn't sure if the car had belonged to me or one of them. In the first place, I was just trying to find, somewhere I can.
Whose IDs did you have?
I really don't even remember. Like, it had been so long ago. I had been locked up for so long. But
you said that they were your family, didn't you?
Yeah.
But you don't remember whose IDs you had?
Yeah, I be talking to my brothers and sisters. I had a few. I think I had like 2 or 3 IDs. I don't remember who, but they told me to hold on to them because they was gonna be using
What were-
drugs, and I usually don't use drugs, so I don't get in the car and drive.
Mr. Hadley, what were their names?
I don't remember exactly which cut. It was quite a few of them, but so much had been going on at the time.
That wasn't my question, Mr. Hadley. Mr. Hadley, you didn't have any keys to that truck you bumped into, did you?
I might have had the keys before. I'm not sure. I might have had the keys before. I might have actually purchased the car. I'm not sure. I ain't gonna lie. I didn't purchase a lot of cars, so I might have actually purchased that car first, and then I might have left the keys inside of somewhere, and they might have grabbed the keys, and then now they might have got the keys to the car. But sometimes I be looking like, I be letting my cousins and all that. I be letting them drive some of my cars sometimes, and they just don't never come back with it. But I don't trip about it,
Mr.
because
Hadley,
I know how it was, and I didn't have a car.
Mr. Hadley, who's Timothy Osborne?
Well, I ain't necessarily sure. I mean, that could have been anybody. Right?
Didn't you tell the officer that the car that you were coming out of was your cousin's?
In the area that I was in, I got a lot of family around that area. I wasn't sure
if I were to tell you that car belonged to Timothy Osborne, who's Timothy Osborne?
I never bothered the car to even. I just accidentally bumped into the car and the alarm went off. It was one of them newer cars. So I mean, the alarm went off if you go get up close to it. So I never got into no car. But
And I'm gonna ask one more time. The car door was open, wasn't it, when the officer came and saw you?
Overruled. You can answer.
I don't remember no car door being open. I didn't see no car door being open.
No further questions, Judge.
Any redirect?
No, you're.
All right, Mr. Hadley, you can take your seat at council table again. Any additional defense witness?
I'm sorry, no, you're.
All right, let me hear arguments from both sides, beginning with the state.
Yes, Your Honor. And I believe that the evidence in this matter is clear, that we heard testimony that Officer Parker responded to 250 Far Road, which was a parking deck by an apartment complex, at which time when he approached, he heard a car alarm going off, and he saw Mr. Hadley inside of the vehicle. That vehicle, based on their way to run license plates, belonged to Mr. Timothy Osborne, which is not Mr. Hadley. The officer stated that Mr. Hadley said Timothy Osborne, or excuse me, the owner of the car belonged to his cousin. Mr. Hadley was also in possession of a screwdriver, which is a tool used for entering autos, and for, again, possession of tools for the commission of a crime. Again, was seen coming out of a vehicle with the car alarm going off. Mr. Hadley did not have keys to that vehicle, nor was he able to turn the alarm off. It wasn't until as the officer testified, Mr. Timothy Osborne came, that was able to turn the alarm towards the vehicle off, We also heard testimony from Mr. Hadley himself, indicating that he was not the owner of the vehicle, that he barely even knew what the vehicle was. He stated that, oh, he was just on top of the vehicle, that he was trying to find a place to rest. Yet we heard testimony again from the officer that the door was open and Mr. Hadley was in it, got out of it, proceeded to walk away while the alarm was going off. We also heard that, again, the objects that he had were not only a screwdriver, but several other identification cards and clothes. Your Honor, ultimately, I would submit based on the evidence here that the state has met its burden in this matter, and that Mr. Hadley should be subject to a revocation as it relates to his 3 open probation cases.
What is the balance, Madam Probation Officer? Do you have that for the 3 different cases for Mr. Hadley?
Yes, Judge. The balance for the 19, well, all 3 cases actually have the same end date, and I show 2 years, 6 months, and 11 days remaining as of today.
Thank you.
You're welcome.
Ms. Hanson.
Your Honor, very clearly, Mr. Hadley is mentally ill. I did not have him evaluated for the purposes of this hearing for several reasons of my own. But he was evaluated last in June of 2019 by the Department of Behavioral Health and Developmental Disabilities. And he was found to be competent to stand trial at that particular point. My former colleague, Ms. Danowitz, handled Mr. Hadley's cases and combined them successfully for a first offender disposition. The first case involved a criminal trespass at a Greyhound station where he was alleged to have thrown a bottle at a security guard. The second case involved theft of cell phones from the Georgia World Congress Center in like maybe less than a year from the first case. And then the final case involved leaving the courthouse and leaving the jail transport van. He was charged with escape as a result of that. That was within 4 months of that middle case. So we're talking about a year and a half of trouble that Mr. Hadley had. And unfortunately, his troubles have not ended. He does have clearly from his testimony a very serious mental illness. I don't think that it's enough to find that he's incompetent to stand trial, but he is very clearly ill. If he believes that a rational person would believe any of that he testified to, he's very clearly mentally ill. The question is what to do with him. He does not, I don't believe that he would be successful in BHTC because it would involve him, first of all, being given housing, second of all, voluntarily taking medications, and third, having a mental health diagnosis, which he does not. So we don't have anything to do with him there, but putting him in a prison environment, Judge, is definitely not going to result in anything helpful to the community, anything helpful to him. He was, I think, appropriately sentenced to 1 year to serve. I don't think he's a good candidate for any particular type of program within the Department of Corrections. So we are stuck before the court, asking the court for mercy. He was in a parking garage trying to get warm. He was homeless. He was and with all of his clothes and his possessions in his backpack. He found a place to get warm. Car alarm went off. Officer came and arrested him. And that was the end of his story. That was 4 months ago. I would ask the court to take that under advisement, that he was homeless at the time, that he had been in jail, that he really doesn't have the resources to find a place to go, and to sentence him to the time served, re-enlarge him on probation, give him another shot, another opportunity to report to probation, and to do what he is supposed to do. With the 2.5 years remaining, I would ask the court to revoke 6 months and suspend the balance, or reinstate him on probation.
So with something like IRSAT, he has to have a diagnosis and has to have a substance abuse issue. I know before he's able to participate in something like that.
Right.
But can he be evaluated in custody to determine if he is at this point would qualify with a mental health diagnosis?
I suppose he could. I would have to, I don't know what the legal mechanism would be to get that done. Ordinarily, it would be a competency issue that I would have him evaluated under. Or I would have to secure the funds from my office to have him evaluated for that kind of diagnosis.
Okay. All right, thank you. I appreciate your candid requests. It makes sense. Enlarging him on bond, though, I think he's going to be right back here and then months down the road in jails, for another hearing on another probation violation, or if not a new charge for a new case. So I do think by a preponderance of the evidence standard that the defense state has met its burden of proof. I appreciate the defendant may have some mental health issues, but he does appear to me competent at the bar of competency for, understanding why he's here, what the charges are, the role of the prosecutor, defense attorney, the court, what potential consequences are, which became evident to me in his efforts to what I believe were untruthful statements to try to prevent finding that he violated probation. So I don't think it's to a level of being incompetent, especially with defense counsel also having that opinion with more interaction with him and with a lot of experience with what it takes to meet that standard in prior clients. So with the 2 years, 6 months, 11 days remaining, I'm going to revoke 18 months. I'm going to order as part of my sentence that he be evaluated and considered for the IRSAT program. Balance will be reinstated. He will be assigned a mental health probation officer. Any other conditions of probation that anybody else requests for the state?
No, Judge, I believe the mental health probation officer would be the appropriate only condition or portion of that.
Anything else for defense? All right, Madam Probation Officer, if you will prepare an order on those 3 revocation cases, revoking the 18 months, reinstating the balance with a notation that I want him evaluated for consideration of IRSAT qualifications, and during probation, he will be assigned a mental health probation officer. Okay?
Yes, yes, Judge.
All right, you can take Mr. Hadley back. All right, I believe state versus Ms. Hanson, are you finished?
I think I am, yeah.
All right, you can. State versus Dan Jackson is next. We ready on Mr. Jackson's case? All right, let's bring out Mr. Jackson. Hi, Mr. Jackson. All right, we have your case on for hearing on a motion to withdraw guilty plea in 19 SC 170206 that was filed by your prior counsel, Mrs. Zimbardi, who represented you through plea and then through filing of this motion to withdraw your plea. And I do have recent filings by your current counsel, a brief and supportive motion to withdraw a plea, and then a motion to reduce or suspend sentence. So let me get announcements from both sides, beginning with the defense, with it being your motions.
We're ready on both of those. Ms. Lombardi is here and she's a possible witness, but she needs to go. She's talked to me and to the district attorney in the department that she said in the plea hearing that this was a negotiated plea. I don't know.
Your Honor. I mean, I would object to, again, the making the representation that way. I think to the extent that the transcript speaks for itself, I think that is fine. But as to what Ms. Zimbardi says or believes, if counsel wants to call her as a witness, if he placed her under subpoena for any reason, I think that would be the appropriate way to deal with that.
She's here. If you want her to testify, you'll need to put her on. Otherwise, I'm not going to take a representation of what she would testify to.
Okay, well, again, we're ready on both motions, the motion to reduce the sentence and the motion to withdraw the guilty plea. We'd like to make sure that this is recorded.
It's being taken down right now.
So we can go ahead and call Ms. Lombardi and get that out of the way.
All right. Ms. Zimbardi, if you'll please come up to the witness stand. The deputy can swear her in.
I do.
Big loud.
Sarah, Sarah, Zimbardi, Zimbardi.
And then, and who do you work for, Ms. Lombardi?
I work for the Fulton County Public Defender's Office.
And you're a licensed attorney in Georgia.
I am.
And on February 24th, 2021, you represent Mr. Dan Jackson,
I did, yes.
Chase 19 SC 170206.
Yes,
And did you attempt to enter a negotiated plea on his behalf?
I did, yes.
And was that negotiated plea accepted?
It was not, no.
Thank you. That's all I have.
Cross.
Yes, Your Honor. Ms. Zimbardi, have you had a chance to review the transcript from that hearing?
I have looked at parts of it. I have not read all of it.
Are you aware that the only time the word negotiated appears is on page 15 of that transcript?
I am not aware of that.
Would seeing a copy of that transcript help refresh your recollection?
Yes, if I have an opportunity to go through it.
Your Honor, may I approach?
Yes. Whose phone? Nobody's speaking up and owning the
And
phone.
that may have been mine, which was on silent, and I'm
That
not
would
sure
explain it.
how it got off silent. I apologize, Your Honor. And after just a quick review of it, that is the only place that I see it in the transcript is on page 15 in two different places on there.
And so that was essentially a joint recommendation that you and the state were making to the court, correct?
The state and I had discussed a negotiated plea and had discussed that at length and figuring out the terms of what we would negotiate and what we'd present to the judge as a negotiated plea.
And you are familiar with the court's standing order, standing case management order, and the standing order that's incorporated within it?
Yes, I am.
And you are familiar with the process of what happens after things like final plea?
Yes, what it says in the standing order.
Okay. In this case, was this case past the final plea procedural posture?
Yes.
What procedural posture was it in when you entered, when Mr. Jackson entered the guilty plea that day?
It was a pretrial hearing.
And did the court essentially inform him previously that she was under no obligation to essentially enter or hear a guilty plea on the case at either that or prior hearings?
I believe she would have done that at the previous hearing.
And at a previous hearing, he did attempt to enter a non-negotiated plea, is that correct?
Yes, he did.
And at that hearing, he withdrew from that non-negotiated plea?
He did.
And did the state did the court inform him about what would happen should he enter a plea at another hearing?
I don't recall exactly what was said, but I believe that she did in some form inform him of future hearings and what was likely.
Including that he wouldn't be able to withdraw his plea at that point?
I believe that would have been included, yes.
And in this case, did the court gave Mr. Jackson the opportunity to stop, I guess, going forward prior to his actually entering a guilty plea? Did it not?
Question. He knows that's not true. Expect the transcript.
I don't think that's a valid objection. Do you have a mischaracterization?
The transcript is one thing when it doesn't. We've got a copy of it. Tell him to point to a point in the transcript where that was said.
Well, I'll overrule the objection, but if you will direct her more pointedly to what you're asking her about, and if she wants to see the transcript, let her see the transcript.
Of course, Judge. So on that date of that this guilty plea was entered, that what we're here for today, didn't the court indicate that to the defendant that before you enter a plea of guilty that you can't withdraw it because you've had that opportunity before. Did she say that?
I don't recall the exact words.
Okay. Was something to that effect, at least?
That is a standard part of her plea colloquy.
And did the court then ask what the defendant's plea was at that point?
I don't recall.
Would seeing a copy of the transcript of that hearing help refresh your recollection?
Yes, it would.
And I'm gonna direct you to page 15 of that transcript.
Okay.
So at that point was essentially was Mr. Jackson given a chance to either say guilty or not guilty at that point?
Can you rephrase with what point?
Yes, of course. So the court informed Mr. Jackson that before he entered a plea of guilty that he can't withdraw it because he's had that opportunity before. Is that correct?
Yes.
And then the court also then asked him after that, she asked him if he understood that. Is that correct?
Yes.
And that after that, the court asked him what was his plea to the 4 counts in the indictment. Is that correct?
Yes.
So at that point, he could have either entered a guilty or not guilty plea. Is that correct?
Yes.
No further questions.
Any redirect?
That's all I know.
Can we excuse Ms. Zimbardi? Any
No,
reason
no,
you're excused?
Thank you.
Any additional witness for the defense?
No, you're right.
Any witness for the state?
No witnesses for the state, Your Honor.
All right, let me hear your argument and pronounce your last name for me,
Rackall.
Mr.
You
Raffle.
know, I'm a private attorney, but the Georgia Public Defenders Council, I guess they have some conflict that appointed me to do this.
Okay,
Your Honor, page 15 of the transcript, Ms. Zimbardi closes her request that the court accept the guilty plea by saying, so we would just ask that you accept that negotiated plea. And the court immediately responds, I know you've been before me before, entered a plea and then withdrew it. It was a non-negotiated plea. So I've offered to accept the guilty plea today if you should choose to enter it. And then the court says, though I'm not bound by the negotiated plea recommendation, you can't withdraw it if I don't go along with it. Again, clearly the court understood this was a negotiated plea, and Rule 33.10 specifically says that if the court is not going to accept a negotiated plea, it has to tell the defendant that and give him the right to withdraw it. So 2 things were not done. He was never given the chance to withdraw this plea. And under the rule and under the cases I cited, Germany, and it says, the quote from Mulkey versus the state, quote, in Lawrence versus the state, 234 Georgia Appeal 603, 1998, this court established a bright line test that requires trial courts to give explicitly the 4 statements required by state versus Germany and Uniform Superior Court Rules 33.10. And that is that if the court intends to reject the plea agreement, the trial court shall on the record inform the defendant personally that the defendant may then withdraw his or her guilty plea as a matter of right. And so that's the situation here. It looks like at the end of the transcript, the court may have been going in that direction, but then the court says on page 20, I will give you an opportunity, but then cuts off and then the hearing ends. So I don't know, but he had an absolute right to withdraw that plea because it was a negotiated plea. The court understood that. Mr. Jackson understood that, Mrs. Zimbardi understood that. Nobody got up and objected and said, this is a non-negotiated plea. It was. And those are the rules on negotiated pleas. And so this defendant is entitled to withdraw that. I also filed the other motion on that. I'm saying that the court has jurisdiction with over 1710-1F. Says within 1 year of the date on which the sentence is imposed, the court imposing the sentence has the jurisdiction, power, and authority to correct or reduce the sentence. Now, this is one thing I could be wrong on, but I have calculated that he's done about 310 days in jail. On April the 5th, it would have been 304, but I'm going by what's stated in the plea transcript. I don't have the exact dates. It was, I think it was 265 days at the plea on February 24th. So he had that 60 some days to that. And it's for about 310 days now. So we're just asking, you know, we don't need to be fighting about this. He's guilty. He wanted to plead guilty. He's now done almost a year. He's sitting in the Fulton County Jail. He can't get into the state system and be paroled. So I'm just suggesting that this could end, this litigation could end if we could figure out a time certain that he needs to serve. You know, I'm just suggesting a year, and then he be released or paroled, and he needs to pay this restitution. He's got 5 years of probation left. And so that was just a suggestion that I had that, you know, instead of going through the radical procedure of withdrawing the plea and going through all this again, then maybe there's a way to resolve this case. That's all my motion to reduce or suspend the sentence is trying to do.
Okay. All right, thank you. We hear from the state.
Yes, Your Honor. Ultimately, Your Honor, I think the issue that is before you is whether or not you consider the plea taken on that date to be negotiated or non-negotiated. And the reason being is that what is cited in the brief that was provided to Your Honor indicates that Mr. Jackson had a right to withdraw, basing it on Uniform Superior Court Rule 33.1. And that case law, and that indicates that when there's a negotiated plea, there are essentially 4 statements or warnings that the court is required to give. Namely, the trial court's not bound by the negotiations, the trial court intends to reject them, the disposition may be less favorable, and the defendant may withdraw before essentially the sentence, I believe, is renounced. And those 4 propositions are cited in the case law that was provided. However, the other situation is that if there is or is considered a non-negotiated plea. And for that, I cite to Rosser, R-O-S-S-E-R, versus State. And that's 273 Georgia Appeals 745. It is a 2005 case. And essentially what that case says is that the right to withdraw in non-negotiated pleas is allowed as of right before the sentence gets announced. However, in the non-negotiated context, once it's announced, there's no obligation to apply or comply with the USCR 33.1. So the question of whether or not those 4, I guess, warnings or statements need to be provided by the court is a question of whether or not the plea is considered negotiated or non-negotiated. And I think further, as that court notes, that just because the state makes a recommendation, that doesn't transform a plea of a non-negotiated plea into a negotiated one. For example, if the state and defense essentially agree to a recommendation. Ultimately, if the court is saying that all pleas after a certain point are non-negotiated, I don't believe that that transforms that non-negotiated plea into a negotiated one just because there might be a joint recommendation provided to Your Honor at a certain point. And Your Honor, looking at the transcript, which I would ask the court to take judicial note of, on page 1, the state says the defendant is entering a plea. State never says negotiated plea. On page 11, it lays out the state will make a recommendation. And just because the state makes that recommendation does not turn it into, I would say, a negotiated plea at that point. I guess it was a joint recommendation, but the question is whether or not it is at that point considered negotiated by the court. The only individuals who do mention negotiated in any statements are the court and defense counsel. In addition, as with respect to the proceedings that day, obviously, I think the record is clear that the plea was freely, voluntarily entered with the full knowledge of the charges against him. And so obviously, I think that standard is clearly met. In addition, in 287 Georgia Appeals 358, the courts do note when it is abundantly clear from the colloquy that the plea was open-ended or non-negotiated, the court can obviously indicate that it was non-negotiated and is not bound by those requirements of USCR 33.1.
What's the name of that case?
I believe it is, and my handwriting is not so good now, but it's Menley versus State. I have MENLY, it looks like. And so, again, when the colloquy itself is abundantly clear that the plea was essentially open-ended, that it doesn't transform, a non-negotiated plea into somehow a negotiated one. And obviously, I would ask the court to take judicial notice of any other hearings that were had in these matters as it relates to Mr. Jackson. So because of that, and because of the way that I have read the transcript, I do believe ultimately this appears to effectively have operated as a non-negotiated plea. But ultimately, I think the finding that Your Honor needs to make is whether or not it is considered non-negotiated or negotiated such that the requirements of USCR 33.10 needed to be met.
All right, thank you. I'll take it under advisement. Take a look at your case law.
Your Honor.
Yes.
Well, Your Honor, it's uncomfortable, unethical. The ADA was not even there at this hearing to get up and try to contradict what this transcript said. It says on page 15, when Mr. Lombardi offers the plea. So we would just ask that you accept that negotiated plea. The court responds, though I'm not bound by the negotiated plea recommendation, you can't withdraw it if I don't go along with it. Again, this is governed by 31.3 and those 3 cases that we cited, Germany, Malta, and Lawrence versus the state. And they're also, we put all 3 citations in our brief. So he has an absolute right to go. And he needed to be told that.
Okay, I will take it under advisement. Anything else for today? You are excused.
Yeah.
No, well, we need to have out the other defendant. Mr. Monson.
Your Honor, I believe that completes my business today. May I be excused?
Who's here for the state?
I believe.
Ms. Sims, Judge?
That's
right.
my case, Your Honor. Melissa Sims for the state.
All right. Yes, sir. Thank you. You can be excused. Hey, good morning, Mr. Monson.
Good morning. How are you today?
I'm well. We have your case on my calendar today for final plea. It is indictment 19 SC 171997, State versus Corwin Monson. I will hear from the state and then from defense counsel where we are on this case. Let me hear from the state.
Thank you, Your Honor. Melissa Sims for the state. Your Honor, the defendant is charged in this case 19 SC 171997 with 1 count of aggravated stalking. The sentence is 1 to 10 years to serve, and a $10,000 fine is the maximum. He's got an unindicted case as well, which is 20 CP 193351. The state has offered a plea offer for the defendant to serve 3 years with the remaining 7 on probation, so 10 to serve 3. We would dismiss the unindicted case, and there would be a permanent protective order against the victim in this case with 100 hours of community service and $1,000 fine.
All right, Mr. Munson, Ms. Gladden, if you will, let me get this defense counsel announcement on where you are with this.
Yes, Your Honor. At this point, my client, and the court, Your Honor, can ask any questions. My client does not wish to accept the state's offer and wishes to go to trial.
Okay. Thank you. All right, Mr. Monson, you have an absolute right to a fair trial. You're under no pressure to do anything today by way of a guilty plea. You can maintain your not guilty plea. You have an absolute right to a fair trial, and you'll get one if you decide to go that route. I have all defendants on a final plea calendar just to afford you an opportunity to enter a plea of guilty if you should choose to do so. A court never has to entertain the plea of guilty, but I commit to doing so up to today's calendar, final plea. I also commit to allowing you to withdraw your guilty plea after I announce what my sentence would be if you don't want to go along with my sentence recommendation. That would be true whether you're entering a non-negotiated plea where your attorney recommends a different sentence than the state. And I hear both sides and hear what is wanted on each side, and then I can announce my plea or my sentence. And if at that point you're like, I'd rather go to trial, you can withdraw your guilty plea up to today only. After today, I don't commit to entertaining a guilty plea at all. And I will not be bound by any negotiated sentence recommendation after today. I will allow you to enter a guilty plea on a case-by-case basis after today. Sometimes I do, but under no circumstance will I allow you to withdraw a guilty plea after today. Even if you and the state come to some kind of lower sentence recommendation and the court doesn't want to go along with it, you can't enter a plea, hear my sentence, and then withdraw it. Do you understand?
Yes, ma'am.
All right. So do you understand what the sentence range is as indicated by the state? 1 to 10 years to serve with up to a $10,000 fine. You understand that's the sentence range?
Yes, Your Honor.
All right. Do you understand the recommendation on sentencing from the state is 10 years to serve 3 years balance of 7 years on probation with conditions of probation of 100 hours of community service and $1,000 fine. And also they would dismiss the unindicted case. Do you understand that's the state's offer today?
Yes, Your Honor.
Is it your desire to enter a guilty plea and either recommend the same sentence or a different sentence today with the opportunity to withdraw, or do you wish to maintain your not guilty plea? Do you know, or do you want to talk to your attorney about it a little further?
Can I talk to my attorney a little further?
Yes, you can. Ms. Gladden, you can go back in the holding cell with him.
Thank you, Your Honor, for giving me just a moment.
Sure.
To talk to Mr. Monson.
Okay, we're back on the record. We're back on the record, Mr. Monson. Let me hear from you after you talk to your attorney. What is your desire today? What is your plea going to be?
Not guilty.
Very well, sir. We will place your case on an upcoming trial calendar. We are placing cases on our trial calendar. It's a court-wide calendar right now. We are limited by judge to sometimes two, I think currently 3 cases per 2-week calendar. And we are looking at cases based on how long a defendant has been in jail primarily, to gauge what cases we put on an upcoming trial calendar. So we will give you notice when your case appears on a trial calendar. We'll give you notice through your attorney as well as publishing a calendar. Anything else for today for the state?
No, Your Honor, thank you.
Defense?
No, Your Honor.
Thank you. You're
Your
excused.
Honor, may I be excused? May I be excused, Your Honor?
Yes, you should be excused, Your Honor.
Yeah.